And I also want to give you a little bit of a background as to where Ohio has come from in order to be able to establish the statutes we have. And then I'm going to ask you, Jack, to talk about some of the factors we looked at. Okay. Back in 2000, a Supreme Court case came down, the United States Supreme Case. That case held grandparents have no constitutional right to association with their grandparents. The establishment of a home, rearing of children, is a fundamental liberty interest protected by the 14th Amendment. The parents, they have the right to, their liberty interest is paramount in order to the duty for the right care and custody of their children. That same Supreme Court said, though, in that decision, but you states do have an interest in the compelling state interest in the welfare of that child. So, if you individual states decide to enact statutes, they have to be very narrowly tailored so that you don't really infringe on the constitutional rights of the parents, and it can only be in certain situations. So they said the relationship usually is beneficial between grandparents and children, so your General Assembly can go ahead and structure a statute and make sure it's narrowly tailored. So in Ohio, what we did in the General Assembly is we took 3 situations because we have to be sure that these situations meet the Supreme Court decision, which talks about if a bond has already been formed or if an event has prevented the formation of the bond between the grandchild and the grandparent. So what we looked at were 3 different situations and came up with 3 statutes. And I wasn't in the General Assembly when we did this, so you can't blame that one on me. So what we did is we said, if the parent of your grandchild is deceased, you can file an action for visitation. If visitation is in order, if the child has an unwed parent, you grandparent can file an action for visitation. And if there's an action for divorce in a family that was a whole unit has fractured, you grandparent can file for visitation. Now those 3 statutes we have to go through, and we have to be sure that when we go through them, we look at different factors to make sure it's in the best interest of the child to have that relationship. And Jack's going to talk a little bit about what those factors are. One factor is the wishes of the parents, and we have to give special weight to that wish. It's not the controlling wish, it's just one of several factors that Jack will address in a few minutes. And again, if you're in one of those 3 limited situations, parent of the child is deceased, the child is born to an unwed mother, or there's a divorce, dissolution, annulment, or anything like that, a grandparent can come in and file for visitation. And I said I was going to talk about 2 different things. I want to go back to that for 1 minute. If we have an intact family, it would be very difficult for us in any way to infringe on that 14th Amendment liberty right. Otherwise, if you're in one of those 3 situations, you can come in and file an action for visitation. And our statutes have been held as constitutional so long as we follow the factors that we have to address. I want to talk about, let's just say one of your children has a child, your grandchild, they are deceased. What's going to happen if that spouse remarries or if the new step-parent wants to adopt the child? Your visitation right to come in and file an action will not be affected. You can still come in and file an action. Now, I just talked about visitation, and I'm now going to talk real quickly about custody. Basically, when we come to custody, we have to basically find the parents as unfit before we can award custody to a non-parent, which would be a grandparent. In order to gain custody, if you think you have an unfit parent, what you would have to do is file a custody action in our juvenile court or a dependency action in our court. And we have to find the parents to be unfit by clear and convincing evidence. It's a very high standard. Here we are at maybe a preponderance of the evidence. Here we are at clear and convincing. And here we are at beyond a reasonable doubt. So it's a very high standard. We are asking if you're seeing things and hearing things, and you know that your grandchildren are being neglected or people are not able to care for them, you need to file a report. Because what you're seeing and hearing needs to be reported so that if we have to do an emergency removal, we have something in place already as far as the investigation in the event we have to do what we call an ex parte emergency removal. I have to say, every day we see grandparents stepping up. We do not have enough foster children for the children that we are signing into care every day. And grandparents in this county are stepping up and stepping in. And if your grandchild has been removed due to being with CSB, you need to act, and you need to act quickly in order for you to be considered as a relative placement, correct? Okay. There's one other situation in a divorce where if I'm doing a divorce trial and I see that neither parent would be in the best interest of the child to be with them, I can certify that action over to juvenile court for that decision to be made there. There's one other issue for you grandparents that is much less complicated, and that's the kinship affidavits. Sometimes your grandchild is left with you, and it's really a problem because you don't have the ability to get your grandchild enrolled in school. You don't have the ability to talk to the doctors. You don't have the ability to look at the school records. You can also file a kinship affidavit, we call it a grandparent affidavit, with the court. And what that does is give you the ability to do the things I just described. And it doesn't involve a long court process because the court isn't involved. It's just filed with us. You need to be aware, though, that it can be terminated or negated by the actions of the parent. But it gives you time. It gives you time to decide what you want to do, or if your child is in a recovery program, and you just need the ability to be able to do the medical decisions and get them enrolled in school. And Jack, if you'd like to come up now and talk for a few minutes about some of the factors besides the wishes of the parents that we need to look at. And we're going to be here to answer questions, but by the ethics, we are not able to answer anything about your specific case. Can I come up?
The judge has done a really good job of explaining the two areas that we're dealing with here. We're dealing with custody and we're dealing with companionship.
You had to say that because I'm his boss.
Yes. And I can't emphasize enough. There are people in this room that have been reformed. And this is an epidemic. It's a tragedy. Candidly, I think, unfortunately, we're losing a generation. And we're trying to come together as a community to help you and get you the best information that we can get you. The judges tried to highlight the fact that we deal with this from a legal perspective. We're giving you the nuts and bolts of what we can do for you or what you can do to help your grandchild. The issue that you're dealing with, oftentimes you're hearing it on the street, well, your grandparents don't have any rights. Well, obviously you do. If unfortunately, and as I say in my courtroom many times, my prayer for the parents in my courtroom are that you predecease your children. The worst thing that can befall a parent is to lose a child. But having said that, the death of a child, that triggers, that allows grandparents to come before the court. The other aspect of this is in an unwed mother situation. You do have rights. Now, we start to look at the factors, and they're set forth in a specific code site. I won't bore you with the code site, but in case some of you are inclined to want to get on the magic box, the computer, you're going to look at Ohio Revised Code Section 3109051, and it deals with something called parenting time rights. The legislature a few years ago took what we used to call visitation or companionship and called it parenting time. So when you see that term, don't be confused. But we're basically looking at what we characterize when we look at whether or not it's in the best interest of the children to have visitation with that third party, that grandparent. We're looking at 16 factors, all right? So we're looking at things such as prior interaction in a relationship that you would have with the grandchild. Geographical location, and I'm going to gloss over these pretty quickly. The child and parents' available time. So in other words, grandparents' available time. We're looking at the age of the child. We're looking at the child's adjustment to homeschool community. And we're also looking at something called an in-camera interview, where we bring the child in the presence of a court reporter, and oftentimes someone called a guardian ad litem or a GAL. You're going to hear that term when you come before us. We're going to talk to the child. We first have to determine whether or not the child has sufficient reasoning ability to make a request, and then we determine whether or not their wishes and desires are reasonable. We look at the health and safety of the child. We look at the amount of time that will be available for the child to spend with siblings. We look at the mental and physical health of all parties. We look at each parent's willingness to reschedule missed parenting time. And obviously, when I say parent, we're substituting in the grandparent in there as well, because they're stepping in the shoes. The relation to parenting time of anyone convicted of any criminal offense, basically, has anybody committed any abuse with regard to the child and the household members.
And that's really important, because you have to be sure that what we're doing is safe for the child.
And
Not
then,
every grandparent's a great grandparent.
you don't mean that literally. You mean that figuratively. Okay. And then we work in close conjunction with Children's Services, who helps us with a lot of this by doing background checks, the SACRIS background checks, site safeties, and the like. We then look to whether the residential parent, there's a shared parenting plan in place. We may actually also have joint custody agreements between the grandparents and the surviving parent in a deceased situation, or we may have some type of other agreement. And we also look at whether a parent has established a residence or planning to establish a residence outside of the state, not just move, but outside of the state. We also look at the parents' wishes and desires, because it does get back to what Judge had said about we do have to give special weight to the wishes of the parents in looking at that. And then there are custody factors that come into play. They're known as the best interest factors. I'm not going to go through all those with you at this point in time. You can ask me afterwards, and I'll be happy to delineate those for you. But bottom line, the term you will hear throughout any proceedings in our court, because our primary focus is the children. So we focus on what are called the best interest factors. So whether they're set forth for custody purposes, for visitation, companionship, or parenting time purposes, we're concerned about what's in the best interest of the children. But you do have rights.
And we do have to go through those factors, as that's what has allowed these three statutes that we can bring an action under to be upheld. Okay, do you want to open us up for any questions? No hypotheticals either that are actually your case.
So what
Boss
we do,
Is we're gonna see if anyone has any questions right now, and I'm gonna have them here as your resource. So raise your hand if you have a question that you'd like to ask right now. You want to do the inaugural question? Okay. Tell us your name first. Use your first name if you want.
My name is Carolyn, and I have custody of my grandson. Both parents are addicts and were incarcerated. And the child was placed in CSB. And my question was, I went through the process. They only allowed me to visit 1 hour a month while I went through this process. That was child services that I believe that was their rule, not the court's rule. But anyways, they awarded me custody. But they told me, CSB told me, that the parents would still have residual rights to the child when they were released from prison, which they were. My son is still an addict and incarcerated, but the mother is now visiting the child and it's not going well. What are my chances and what's the benefit of adopting the child? Can I prevent? Can I get away from what's going on in his life? Or will I have to deal with it by filing contempt on the visitation?
Again, you're asking us about a particular case that I would assume is before court.
I live in Portage County.
Okay. In any event, if you were thinking adoption might be an option, you would need to file in probate court. And that's the best I can answer that unless you want to take a step.
I think the frustration for you is that the parents continue to have rights after you got custody. And
Yes.
that is under the law, they do. You received the children, you received legal custody of the children. The parents still have rights to file for custody or visitation. They still have those rights to do that. But they would have to show, for visitation purposes, I read you the factors that they would have to show.
Yeah, they have visitation.
Well, for custody though, if they were to try to get custody, they would have to first show something called change in circumstances, and then they would have to show that it's in the best interest of the children. Okay, and it's a pretty, as the judge pointed out, it's a thorough and convincing standard. It was very difficult, but I can't speak to the individual aspects of your case.
And as far as adoption, there's another whole statute that covers that, so we'll have to take a look at that and be honest with each other. Anybody
you.
else?
Jody, you're gonna get a workout.
Oh my goodness, I'm gonna pass out. Okay, where to go? Yes.
Jody, and we have a specialized docket in our court, and that's our family dependency court. And what we do in that court is children who have been removed from their parents because of an addiction, if they are able to be certified into our special docket court, we put them through an intense program of treatment with the hope for reunification. And that's Jody up there, who is our